Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Today I will be sharing with you some information based on a question I received today. That's like a two-part way to actually get to my question. So I'm not even going to tell you that if you need to speak with me, go to Frank at Frank Bruno Law. I received a question today. It was a telephone inquiry from a potential client, and the scenario, really, it was interesting. This person identified as the granddaughter of an individual that passed away. Now, this individual had raised her mother from when the mother was a young girl, about 5 years old. He had been the long-time companion of her grandmother. And this gentleman raised her mother from the age of 5. And this, the young lady that called me, had always called this individual her grandfather. Now, he had created a will, and he had left her a piece of property, and that was done through a deed. So there's clearly a long-standing relationship, an affection, a bond, because a piece of property was left to her during his life. He put it in her name. He wrote a will, leaving bank accounts and stocks and bonds and whatever his monetary assets were to this person that called me. And they have she has a copy of the will, but she does not have the original will. That's the situation. No original will, just a copy. No blood or legal relationship between her and this individual that she identified as a grandfather. He identified with her, from what she told me, as a granddaughter. The original will can't be found. You cannot probate a copy. No blood or legal relationship. He never adopted her mother. There was just a love, a family bond, but no legal relationship. So really, she's out of luck. I felt terrible, and there's nothing else to do. So it would help if we keep these documents in a place that it can be located. Now, the reason for this really is it's because a will, I'll give you a different scenario. Say I use myself speaking in the first person. If I made a will and I gave everything to a very close and dear friend of mine, forget that I'm married with children, I'm a single guy, I make a will to my dear friend, and then we have a falling out. Or say I choose to leave everything that I have to a cousin or a child or someone else. And let me go back to the start of the story. I leave everything to a friend in this story, and I give him a copy of the will. But then the next day or a couple of weeks later, I choose to change my mind, and I leave everything to a cousin. So now my cousin John has everything, and I give him a copy of the will, and the original will is leaving everything from me to John. My dear friend will show a copy of the will, but that won't be effective. Why? Because I have the ability to change my mind. A copy of a will is not a useful document. In some instances, you have a copy and the original was in a home and the home burned down. Could you probate a copy? Yes, in that instance, but not this scenario. So if you would like to discuss your specific fact situation, please give me a ring or an email, Frank at Frank Bruno Law. Thank you. I'm mixing all my metaphors. Ring and email. Email is good. Bye-bye.